Okay, wonderful. Well, welcome everyone to our second Zaremski lecture of the semester. We are very grateful to Miles and Elena Zaremski for their support and the funding that enables these events to occur. If you are joining us online, please put your questions in the Q&A. We do have somebody monitoring it. So we are delighted to have with us Professor Leslie Wolf, who is the Ben Johnson Jr. Chair in Law, Distinguished University Professor and Director of the Center for Law, Health, and Society at Georgia State University's College of Law. She also has an appointment with the School of Public Health and is an adjunct professor in the Department of Family and Community Medicine at the Medical College of Georgia at Augusta University. Previously, she was on the faculty of the University of California, San Francisco for about a decade. Professor Wolf conducts research in a variety of areas in health and public health law and ethics, with a particular focus on research ethics. She has served on the Department of Health and Human Services Advisory Committee on Human Research Protections and is still serving on its subcommittee. She is a graduate of Johns Hopkins School of Public Health, Harvard Law School, and Stanford University. She also was a Greenwall Fellow in Bioethics and Health Policy and a Greenwall Faculty Scholar, which is a huge honor. Her lecture today is entitled Equal Rights and Protections in Human Subjects Research, a Call to Action. Professor Wolf.
Thank you so much, Sharona. It's such a privilege to be here today and to be able to present this work. I'm very grateful for the invitation. I'm going to apologize in advance. I have a new computer. Usually I have slides, not that they are essential to the presentation, but as my bio said, I'm used to working in medical school where you always have to have it. To start, let me say that the work is a collaboration with my longtime collaborator, Laura Bascow, that was supported in part by a grant from the National Human Genome Research Institute, although in the usual disclaimers, the content is purely our own, and the paper will be published in the spring in the Journal of Healthcare Law and Policy. The core principle that motivates the presentation in our paper is that biomedical research plays a critical role in improving the health and well-being of all of us, that we've achieved giant strides in a lot of places because of biomedical and behavioral research. But we also recognize that the weight of evidence demonstrates that the benefits of research are not shared equally. And to ensure that everyone benefits from research, we need research that successfully enrolls individuals that reflect the full diversity of populations, including in terms of age, sex, race, ethnicity, sexual orientation, socioeconomic status, geography, etc. But our research regulations that were adopted to protect human participants in research actually have provisions that result in unequal protections, and we contend that those must change. To persuade you of this, I'm going to start off by providing a background on the U.S. regulations governing human subjects research, describe the two inequities that we've identified through our research, discuss a strategy for remedying the inequities, and then recommend some specific changes to remedy those inequalities. So I have to start off, as most people who are talking about research ethics need to, with our history of research abuses. And there is a very long and depressing history of abuse of vulnerable humans for research purposes. But for purposes of understanding the U.S. research regulations, I'm going to focus on the U.S. Public Health Service's Tuskegee syphilis study. Many of you may be familiar with it, but I want to share just some key facts so that we have an understanding. It was a study that was conducted over a period of 40 years in rural Alabama among African American men There were 600 men, 400 of whom had syphilis and were left untreated for the period of time. And not only were they left untreated, some of them were even they were prevented in the area from receiving penicillin when it became available. Like, there was a letter that said, do not give the men in this study penicillin. Some of them did receive it through their service in the military and in other ways. They were told that they had bad blood, and it is not clear that they ever knew that that was a term that was intended to mean syphilis, and it's not clear that they were ever told they were in a research study. It was not a sequence study. There were multiple publications over the years, and at various times the government came together and considered, should we continue? And each and every time they decided they would continue, in part because they felt they could never do this research again. And we also know that some of the partners and the children of the men were infected over the years. On July 25th, 1972, the Associated Press reporter, Jean Heller, revealed the study with headlines saying syphilis victims in U.S. study went untreated for 40 years. Although this was not the first story of research abuse that had been reported in the newspapers, the response to Heller's reporting prompted different response. The government responded quickly. You had an investigation from the then Department of Health, Education, and Welfare that resulted in the termination of the study in 1972. You also got congressional hearings that were conducted by Senator Ted Kennedy. Timing may be a factor here, right? With the civil rights movement, Vietnam War protests, among other things, there was a lot of concern about questioning the government. And so this revelations of abuse of Black men over a 40-year period got traction in ways that hadn't before. Senator Kennedy, as I mentioned, held multiple congressional hearings in February and March of 1973. And those documented research abuses that extended well beyond the U.S. Public Health Service syphilis study. And as a result of the study revelations and the hearings, we ended up with the National Research Act, which was enacted with broad bipartisan support in July of 1974. It created the National Commission for the Protection of Human Subjects of Biomedical and Behavioral Research, which was instructed to do, among other things, identify the basic ethical principles which should underlie the conduct of biomedical and behavioral research involving human subjects, and to develop guidelines to assure that it is conducted in accordance with such principles. Among the many reports the Commission produced is probably the most famous one, the Belmont Report, which set forth 3 of the foundational principles of research ethics that remain touchstones today. These principles are incorporated into the regulations governing human subjects research, which is known as the Common Rule. I want to just give you a little bit of an overview about the Belmont Report and the regulations themselves. The 3 core ethical principles that the National Commission identified are respect for persons, beneficence, and justice. They defined respect for person as acknowledging an individual's autonomy with a corresponding obligation to protect those with diminished autonomy, and is operationalized by requiring research participants to consent. So researchers have an obligation to obtain informed consent. Beneficence encompasses the obligation to avoid harm and to actively promote good. And it generally is operationalized as the idea of maximizing the potential benefits from research and minimizing possible harms. Finally, justice is a distributed concept in this context. That is, it's operationalized by requiring equitable selection of subjects and looking to make sure that the benefits and the burdens of research are equitably distributed. So following the directives of the National Research Act, the Department of Health and Human Services promulgated regulations governing human subjects in 45 CFR 46. It's referred to as the Common Rule because some 15 federal departments and agencies at the time in 1991 signed on to it. After more recent revisions in 2018, there are now 20 Common Rule departments and agencies. And they are the requirements here are very similar to the ones there are separate regulations for FDA. There are many details contained in the regulations, and I'm going to focus on those that are relevant to our discussion. First, they apply to research that is conducted or supported or otherwise subject to the regulation of a Common Rule department or agency. That means it does not apply to research that does not receive federal funding. Some of you may be familiar with, there was an experiment now several years ago that was done by Facebook, where they altered the feeds that people would get. And it was called the contagion experiment. They were looking at whether what you received in your feed would change your mood. That would be an example of something that is not subject to the whole regulatory system, because Facebook is not one of those institutions that would receive funding for this study. Now, some institutions voluntarily agree to apply the Common Rule to all of the research that they conduct, but of course they're not required to. There used to be an administrative incentive to do so. You could check a box on what is called the federal assurance with the federal government that pertains to requirements under the Common Rule. But there was a movement to uncheck the box so that institutions would not find themselves liable for should there be any violation on such research when they were not obligated to comply. And with the 2018 revisions, there's no longer an option to check the box. So it's less clear how institutions are dealing with. They're certainly not promising to apply the Common Rule in the same way. So what are some of the key features of the Common Rule? First, IRB review must be done before research commences. That is, an institutional review board reviews the protocol, the consent document, according to criteria that are set out in the Common Rule. And the key criteria are consistent with the Belmont report and what we tend to think about. That there is informed consent that will be sought and documented, that the risks will be minimized and that will be reasonable in relation to the anticipated benefits, and that subjects will be selected equitably. As I say, there are some other requirements, but those are some of the core components to it. So, what are some of the inequalities that are inherent in the Common Rule? The first is this one, that the protections extend only to federally conducted or funded research. And what that means is that participants who are recruited at the same institution may have different protections, right? And the National Bioethics Advisory Commission identified this gap as ethically indefensible difference in protection and as a fundamental flaw in the Common Rule back in 2001. So we're clearly not the first to identify this ethical gap. In doing so, in naming this problem, NBAC stated the commitment to protect participants should not be voluntary, nor should requirements be adhered to for only some human research. And we certainly agree with that assessment, in the sense that people who understand that there are these provisions would feel betrayed to find out that they are not necessarily receiving those protections. Again, we're not the only people who agree. The Institute of Medicine, in a report in 2003, Responsible Research, a Systems Approach to Protecting Research Participants, stated the committee agrees with NBAC that research protections should extend to the entire private sector as a responsible system of protection should be afforded to all who volunteer to participate in research, regardless of sponsor or location. Therefore, the first and essential step in improving the current system of protection is required that it be in place universally. The Department of Health and Human Services had an opportunity to correct this gap, this long-standing gap, when they sought to revise the Common Rule back in 2011. They put out an advance notice of proposed rulemaking in which they asked whether the Common Rule should be extended to non-federally funded research at institutions receiving federal funding. Note that that is still narrower than what NBAC or IOM were suggesting, but at least it was a step forward. In the 2015 Notice of Proposed Rulemaking that HHS put out, they narrowed the proposal to extend the Common Rule to clinical trials, regardless of funding at institutions receiving federal funding. Yet, when the time came to issue the final rule, the Department of Health and Human Services chose not to close this gap in any way. They determined that the Common Rule departments and agencies do not have statutory authority to directly apply the Common Rule to all human subjects research conducted in the United States, and also said, upon reflection on the perspectives expressed by public commentators, we are persuaded that the proposed extension of the Common Rule is not appropriate to include in the final rule at this time. We will continue to carefully consider the related issues. But I think it's really important to understand this was the first time in 25 years that HHS had tried to amend the Common Rule. So we're probably not going to have another chance soon for HHS to try to change this. So it seems like a very significant missed opportunity. That said, the unequal treatment of participants in research actually goes much deeper than those who are left out of federal regulatory protections. In fact, there are inequalities that are created by state law. The Common Rule explicitly provides this policy does not affect any state or local laws or regulations, including tribal law passed by the official governing body of an American Indian or Alaska Native tribe, that may otherwise be applicable and that provide additional protections for human subjects. That means it does not preempt other state laws. And we previously conducted a study of state laws that combined with federal law to create what we refer to as the web of legal protections. Our work there was published in Case Western's Health Matrix, and I'm pretty sure, given how statutory it was, the students are still cursing us for all the hard work they put into it. But the result of what we found in our study was that there is substantial and substantive state law variation that can result in research participants in the same study having different rights and protections depending on where they live and where the research is conducted. So you can imagine a study that is being conducted across the entire United States, that whatever is happening in Ohio, those laws may be different than where I am in Georgia, and if we all sign up, we will have different rights and protections. So let me give you some examples of what we found and what that might mean. So you may be familiar with the Genetic Information Non-Discrimination Act, which is federal law that provides some protections about about discrimination based on genetic information. The federal threshold for employers is it only applies to employers who have 15 or more employees. So if you are in a small employer, which at the time we did our research was about 17% of Americans, then you're not covered by GINA if you're in the employment context. What we found, though, is that a number of states have adopted different, similar GINA-like protections for employment discrimination and have very different thresholds. So 17 had put it down to and made it apply to employers who had 5 or more employees, and 11 states went down to having just 1 employee. We also found, so GINA also has protections for use in health insurance, but only health insurance. But we found some states, 4, that extended to other insurance, like life, disability, long-term care insurance. Some of those kinds of policies that will become more and more relevant as we have an aging population. Let me give you some other examples. So the ADA, the Americans with Disabilities Act, similarly applies to employers that have 15 or more employees. And again, states have stepped in and said, no, we want our state laws that mimic the protections that are available under the Americans with Disability Act to apply to smaller employees, with 10 of them going as low as 1 employee. We also found that some state medical or genetic privacy statutes explicitly provide a right to sue and statutory damages, attorney's fees, and costs, protections that are not available under HIPAA. Right? So HIPAA doesn't have a private right of action. You have to go to the Office of Civil Rights and complain there and see whether they will take an enforcement action that may not bring you something. And we think that these are relevant because they certainly extend the protections that some people have, as well as make it possible for some people to bring a claim, to enforce their rights when they've been violated. Now, there can be challenges. If you are the IRB sitting there trying to figure out, okay, what do we do with this? There are challenges to resolving the conflicts. We heard, as we talked about this issue, and as we consulted with large national research, that some IRBs would say, it's okay. We'll just apply the strictest law. That's easy. Well, that's what we'll do. That way we're adding the most protections that we could. There's a problem with that. Sometimes you can do that, right? So if the protection is that certain information needs to be disclosed, and you have to disclose it in Ohio, but you don't need to disclose it in Georgia, you're not prevented from disclosing it in Georgia, so we'll just be more, we will disclose everything, and that way everybody will be protected. But when we're talking about substantive protections, they can't be extended. The IRB can't say, oh, well, our GINA-like or ADA-like protections will go down to 1 employee, employers that just have 1. They don't have the authority to do that. They also can't extend the private right to sue or to grant statutory damages, attorney's fees, and costs that may facilitate the ability to actually bring a claim if the statute is not there. So we think we then go to our call for action. Since HHS did not, and likely will not, act to close the gap because it believes it lacks statutory authority, we need to turn to Congress. We need to ask Congress to close the gap and to provide uniform rights and protections to human subjects for studies across the United States. Think a system that treats some participants differently based on where they live or where the researchers are based creates an opportunity to exacerbate rather than alleviate distrust. Thus, it's imperative for Congress to also remedy the inequalities in procedural and substantive research protections available to participants that state law variation produces, so that all participants, regardless of study site or state of residence, would be uniformly protected. We've done research previously that has also looked at the congressional authority to do this. And we conclude that Congress absolutely has the power to do this under the Commerce Clause. We looked at it in the context of the Certificate of Confidentiality, which is a special legal tool that provides protections for confidential research data or sensitive research data. But we situated that within broader research and what Congress has done over 100 years or more to facilitate and extend research within the country. And having looked at all of the different steps it has done, as well as to look at the enormous amounts of money that is embedded in and invested in the research system, suggests this falls very squarely within Congress's commerce. And it is something that Congress has repeatedly gone back to. You know, for research, certainly it established, again, over 100 years ago, what would become the NIH. It also, as I mentioned earlier, created the National Research Act in 1974, which very explicitly notes its intention to foster national research, both through its funding and from its oversight. And more recently, in 2016, with the 21st Century Cures Act, and with its current work looking at what is referred to sometimes as 21st Century Cures Act 2.0. So we believe, as I say, that Congress can work to rectify these problems and should close the gap of extending the common rule and making sure that everybody who's participating in a research study across the United States receives the same protections, and to think carefully about what are the substantive protections besides what we already have embedded of consent that we want, and risk minimization and equitable selection that we want participants to have. So what should Congress do there? You know, obviously extend common rule to research regardless of funding, and then to think about those key procedural and substantive research protections. We think that what the states are doing is a good place to start to think about what those key procedural and substantive protections are. We look and we say, if states can extend genus protections to smaller employees and to non-health insurance, certainly the federal government, if they've established it's possible to do so, that things have not collapsed in those states, they're long-standing at this point, that the federal government could do the same. As I say, we think that it would be appropriate to provide a right to sue and authorize statutory damages, attorney's fees, and costs for when there are violations of the protections that are afforded under the common rule. A lot of times there may be violations that do not give rise to significant injury. They're not going to be the kind of thing, you know, there certainly are those examples in which somebody is seriously harmed, up to and including death as a result of research participant. The more common thing is that confidentiality is breached in ways that may create harm for somebody, may create reputation damage, but do not rise to the kind of thing that you're going to be able to find a plaintiff's lawyer and bring a lawsuit. But having some kind of statutory damages will allow those who have suffered a breach, for example, to bring a claim and create incentives for researchers to pay more attention to some of these. We do think, though, for those times where there are research injuries, that we ought to have a system that requires compensation for. There has been a long-standing debate within the research ethics community about requiring research compensation. If you look to other countries, they provide it. Some of it is because they have universal coverage, national health systems that we don't have, but some of them have adopted insurance mechanisms. And we have some examples of those in the United States. We have some institutions who have elected to provide insurance so that they know they can compensate and provide care for somebody who is compensated for their research injuries. But the covenant rule just requires that we say whether compensation is going to be available. It doesn't require institutions and researchers to provide it. We think that would be one thing to change. So those are some places to start. I do not consider that an exhaustive list by any stretch of the imagination. And we think that certainly it would be wise of Congress to hold hearings, to engage stakeholders, to inform its decision-making. And certainly they have the power to bring together people to inform them. And I would say not just the institutions, but those who have been working in the area of research ethics and been studying these things, especially from an empirical basis, and from those who are participants, and particularly those participants who have been injured in some way as a result of research participation, so that we are, in fact, thinking expansively about what ought to be in this, again, imagining that it will not be an opportunity that will come frequently. We recognize in making this, the statement that the congressional action we propose will certainly not resolve all issues, right? It will not all of a sudden become a fully equitable system. For example, we know that researchers' decisions concerning which populations to study, where and how they're going to recruit, and their willingness to work within communities to earn trust will affect who is asked and who agrees to participate in research. But our view of it is that ensuring all participants are afforded the same rights and protections will provide the structure necessary to facilitate truly inclusive research that can lead to discoveries essential to ameliorating health disparities and advancing equality. And that we need to restore some trust by having a system that treats participants equally in a way that I think is consistent with what people understand in the wake of Tuskegee, in the wake of more recent discussions about Henrietta Lacks, and the surprise people often have that, in fact, you could do the same thing today, take her cells and convert it into cell lines without permission. So sort of looking forward comprehensively about the kinds of provisions that we have. So that is the end of my formal remarks, but I welcome any and all questions.
Thanks so much, Professor Wolf. That was great. Again, if you are online, please feel free to add a question into the Q&A. We do have somebody monitoring that. And we'll take questions from the audience that is present. I will ask you a question to begin with. How would you respond to the objection that a private cause of action will raise research costs, delay research advancement, and so on? We just studied in our health law class that most medical malpractice claims that are filed actually do not have merit, and very few of the ones that have merit actually get litigated. And is that possible as something that would happen in the research arena as well?
So when I teach that, I often look on the malpractice side that in fact, well, I guess as you mentioned, many of those that have merit do not get get brought. So I'm a little, not as concerned about the tort system from that perspective. My own view on this particular one is that there are very, very few resources for participants. And so we do need something for accountability. And that we have them for other spaces in medical, not HIPAA, but in states for breaches of confidentiality. They're not extensive, right? It is, you would need, it tends to be like $500 or $1,000. It's per violation, but it certainly then creates an incentive to have better systems, and requires that we make sure that we are in fact protecting somebody. And I would say that the other piece, of course, research is different in the sense that we ask people to take on risks, even if they're only small risks of confidentiality, to benefit the rest of us. And we ought to have a system that recognizes that, and if they are injured, that they receive some compensation.
Professor Melman, but we're waiting for the microphone to come around.
Thank you, Leslie, for that excellent talk. I wonder if you have any views you would share with us about learning healthcare systems and their approach to, their practice, or at least some of them have a practice of not treating patients who opt out of clinical studies that are embedded in their systems. I don't know if the audience knows much about what those are, but I just wondered if you had any thoughts about that.
So I've not looked at learning health systems as deeply as I think, certainly as others, but I think what's going on there is similar to some of the other issues that come up with waiver of consent, with exempt research, that there are things that we do in research that people are surprised about. So, I brought up the Facebook contagion experiment just because it did at the time get in the news, and it's a good example of something that happens outside the research structure. And people were upset, right? And I think I'm not suggesting we get rid of some of these things, but I think we need to do a better job of letting people know the research that we're doing that may not be being done without consent. And just be more honest about the hows and why we're conducting research, including within systems. And I certainly, the learning health system sort of does put things in a very different space than what we have traditionally understood. And I think that, if we are breaking trust with how people understand it, we run the risk of undermining so much more of the work that we're doing.
Professor Melman, just for the sake of the students, could you explain learning health system very briefly?
Yeah, so learning health systems are basically provider institutions, typically hospitals and hospital systems, that are conducting clinical research, and they basically enroll their patients in these studies, and the patient pretty much has to participate in these studies in order to get treated at that institution. They can opt out, although it's not always easy for them to do that. But if so, the hospital may say, well, I'm sorry, but you can't be here anymore. We can't care for you. And I mean, to me, that's pretty outrageous, particularly if that's the only hospital in town. And I just, and there's been a back and forth among research bioethicists about this, but there's a lot of enthusiasm for this approach, including from some bioethicists. So I'm perplexed by it, and I just, always interested in expert opinions about it, because maybe my concerns are not significant. Does that help?
I agree with you, Professor Melman. I'm always concerned when we are upending and not actually keeping participants fully involved in that.
Okay. Kim, we're just going to wait for the mic.
Have you and your colleagues talked with the Association for Accreditation for Human Research Protection Program, or AHARP?
We've not spoken with AHARP with respect to this component of things. We're familiar with the accreditation process, for sure.
Okay. Because basically that group is mandating IRBs to look at the regulations and appropriately interpret them, and then actually go above and beyond.
Certainly, as a process, they require, to gain that accreditation, you are developing policies and processes that are intended to elevate the review. But it doesn't. It's within the current system as well, right? And it becomes a challenge. Yes, it's intending to promote the highest level, but it doesn't change the inherent inequalities of the system.
So we have a question from the online audience, and Lucas is going to read it.
Yeah. So the online guest, she remarks about how she's read an article about a hospital that was doing unethical research, and she says it seems like there is a gap between OHRP, the FDA, and the IRB, and she asks, are there better ways to close these gaps so that patients are well protected?
So it's a little hard without a little bit more of the actual experience, but let me at least say that so OHRP is the Office for Human Research Protections. It is the federal agency that oversees the human subject protections, and it provides guidance and also does some oversight. It has been identified in Office of Inspector General that it does not do a lot of oversight, and that may be one of the problems in which we are not doing assessments of the institutions and their human research protection programs. FDA does do more audits. They have, as I mentioned, have their own regulations, although the content is pretty much the same. They do more, but not, again, nobody does as many audits as are possible. And then the IRBs are to be looking to the guidance and from OHRP, but again, there's not a lot of enforcement in that regard.
We have one more question from online.
Yeah. Could a Henrietta Lacks situation ever happen again?
So yes, let me be very clear about that, right? So let me give a little background on Henrietta Lacks and then explain why. So Henrietta Lacks was an African American woman who was treated at Johns Hopkins for ovarian cancer. And during her surgery, they removed some cells. They proved to be very interesting, and they were able to make the cell line out of that. They were taken, she and her family were unaware that those cells were taken and developed into a cell line that has been used in so much research and has been informative in so many ways. And the rules under the common rule that you may still, if there is not information about who the person is, if they're de-identified, it may not be considered human subject research at all, or it may be considered exempt if it's de-identified, or it still could be conducted under a waiver of consent. So there are multiple ways that you can still use biological materials under the existing regs that would be very similar to Henrietta Lacks. That was one of the issues that during the advanced notice of proposed rulemaking, the notice of proposed rulemaking into the final rule, that they considered changing, that they thought about perhaps requiring consent for all research involving human biospecimens. With Henrietta Lacks' story and the book, The Immortal Life, Life of Henrietta Lacks by Rebecca Skloot, and now, the movie with Oprah Winfrey, that they thought about closing it, and they chose not to close that. And I think, again, one of those things, and a misunderstanding, because so much attention to that story, you would think, of course we can't do that again. But under the regulations, you can.
All right, other questions? Anybody have anything? Yes, Michael. We're going to wait.
So you says according to the common rule, at first it only applies to those institutions taking the federal funds or like carried out by the federal government. I wonder, is that a product of the federalism? Like it just because they can't make the rule like applies to everyone?
So I wondered about that myself initially, and then my colleagues and I did some research on the legal underpinning for, as I said, this legal tool called the Certificate of Confidentiality, because we get questions about that all the time as well. And based on our constitutional analysis there, something I can't say that I've done a lot of times, that we looked and found, no, actually it's firmly within Commerce Clause authority, in part because of, certainly Congress thinks so. It's taken multiple steps over really 100 years and more. And when you look at how research is conducted today, it is clearly multi-site and multi-state, and the enormous sums of money that are involved. And in our article, Constitutional Confidentiality, we discussed that particular analysis in great detail. But I also think that HHS feels it can't because it's a regulation, and given what recent Supreme Court decisions, I think we have to look to Congress and not expect the agency to close that gap.
Yes.
Hi, thank you so much for your talk. I had a question about, or kind of just looking for your point of view on the use of genetic information that people have given over for commercial reasons, like 23andMe and like all of those tests. Once individuals hand over that information, is any of it protected from researchers wanting to do a major like meta-analysis, or do they give up any protection by participating in this product?
So there are consent forms that go along with the transfer of that information into the research side of things. And there may be some protections, but again, some of this work can be done if it is so-called de-identified, and the current regulations don't necessarily consider DNA de-identified, despite the fact we can't change it. And so there are ways to do research, and particularly large-scale research with those resources, where you promise we're not going to share identifiers. But there's also quite a bit of research out in the literature demonstrating that people with certain skills can easily connect up people, including based on DNA, connecting it with other more publicly available resources. As I say, it takes somebody with many more skills than I have, but those with those skills have found it to be relatively easy.
Buddy, do you have a question? Okay, the microphone is coming.
Yeah, thanks for your talk. I guess actually the last person's question raised this. Is there a sort of federal standard for de-identification of health data or anything? From my understanding, at least, there are a couple of methods, but I was just wondering, is there any specific federal standard?
So the federal standard that people look to tends to be HIPAA, right, which has 18 different identifiers. And in the common rule, there also is this idea that you cannot readily identify someone from the information, or there's a there's a small risk, right? And there was a call. This is an issue that was certainly of concern during the revisions, and there was a mandate in the revisions to look at, with this recognition, technology changes and it becomes earlier, that they should look at and create standards. To the best of my knowledge, nobody in the government has looked at that, despite the mandate, and we are now more than 4 years in, which is what the time frame was, to actually see whether we need to update those standards.
All right, anything else? Well, great. I think afternoon classes will start soon, so thank you so much. This was a wonderful program, and we appreciate your joining us. All right, bye-bye.
Take care.
I'm rooting for him, you know? I tell you. My dad, he passed. He was a huge